A smelter factory was established in Trail in British Columbia, Canada in 1896, which, since 1906, had been owned and operated by the Consolidated Mining and Smelting Company of Canada Limited, or Cominco. The distance from Trail to the boundary line is about 7 miles, following the course of the river and possibly a slightly shorter distance by following the contour of the valley. The factory was involved in the smelting of zinc and lead ores in significant quantities, leading it to become one of the best and largest equipped smelting plants on this continent. The development of the smelter between 1925 and 1927 through the erection of 2 high chimney stacks of approximately 410 feet not only increased further its level of production but increased the quantity and concentration of sulfur dioxide emitted as a consequence. The tonnage of sulfur emitted from the smelter rose substantially over the first 3 decades of the 20th century. From 1925 at least to the end of 1931, damage occurred in the state of Washington resulting from sulfur dioxide emitted from the Trail smelter. The smoke drifting from the smelter across the border into Washington allegedly caused damages to crops and forests. The smoke generated from the smelter became the source of complaints from American residents. Complaints included sulfur dioxide gases in the form of some smoke generated from the smelter was directed into the Columbia River Valley by prevailing winds, scorching crops and accelerating forest loss. Effects of the smoke, as investigated by the U.S. Department of Agriculture, included both visible damage in terms of burned leaves and declining soil productivity. After the complaints in 1925 regarding crop and forest destruction as a result of smoke from the smelter, Cominco accepted responsibility and offered to compensate the farmers who were affected. Cominco also proposed installing fume controlling technologies to limit future damage and reduce the emissions of sulfur dioxide. The company also tried to offer payments to the affected residents or even offered to purchase the land outright, which some would have accepted. However, the company was denied this method of compensation because of Washington state's prohibition of property ownership by foreigners. This led to the official petition by the farmers and landowners of Washington in 1927 for state and federal support against the smelter, claiming the smoke was damaging United States lands. In 1931, the ICJ awarded the farmers $350,000 in damages, but did not set guidelines for sulfur dioxide emission reduction. The compensation was far less than the plaintiffs had expected, and the ICJ settlement was eventually rejected under the pressure of Washington State's congressional delegation. The unsatisfactory result of the ICJ decision led to the establishment of a 3-person arbitral tribunal to resolve the dispute in 1935. The arbitral tribunal was established by means of an international agreement, the Convention for Settlement of Difficulties Arising from Operation of Smelter at Trail, BC, signed and ratified in 1935. The convention outlined 11 articles under which the tribunal would operate. The arbitration case was originally between the farmers in the affected area and Cominco. However, what started off as a smelter versus agriculturalists evolved when regional and federal agents became involved, resulting in the dispute becoming an international issue.
Good day. The video you just saw meant to give you an insight of the discussion today. I am Joanne, and with me is Pam.
Hi.
And Ray. The Trail Smelter dispute was a transboundary pollution case involving the federal governments of both Canada and United States. As I understand, this was referred to IJC. What is IJC, Pam? What was their role in this case?
Yes, so indeed, this dispute was referred to IJC, or the International Joint Commission, as a result of the bilateral treaty that both states entered into in 1909. The purpose of the Commission of IJC is to prevent boundary disputes, specifically concerning waters, in order to establish sovereignty among two nations. Under Article 5, disputes along the common frontier shall be referred from time to time to the International Joint Commission, as stipulated in the International Boundary Waters Treaty in 1909. This treaty specifically points out that one of its purposes is to prevent pollution on either side to the injury of health or property on the other. The IGC therefore was given the responsibility to create the case.
I see. However, from what I learned, that the decision laid down by the IJC in 1931 awarded the farmers much less than the farmers had sought. Additionally, this was the first time the IJC ruled on a transboundary pollution case. And so, the US State Department flatly rejected the decision and submitted for arbitration. This resulted in diplomatic maneuvering which led to arbitral tribunal. It was the tribunal's decision that produced the most significant result in this dispute. So having learned the precedents of this case, let's now go to the issue which will be enumerated by Dre.
It was not until 1935 that a convention was signed in Ottawa, Ontario, Canada that legitimized the tribunal, the Convention for Settlement of Difficulties Arising from Operation of Smelter at Trail. It outlined 11 articles under which the tribunal would operate. Of the 11 articles, Article 3 outlines the 4 questions tribunal was to answer. First, whether damage caused by the Trail Smelter in the state of Washington has occurred since the first day of January 1932, and if so, what indemnity should be paid. In the event of the answer to the first part of the preceding question being in positive, to what extent should there be compensation? Third, in light of the answer to the preceding question, what measures or regime, if any, should be adopted or maintained by the Trail Smelter? Lastly, what indemnity or compensation, if any, should be paid because of any decision or decisions rendered by the tribunal pursuant to the next two preceding questions?
So the tribunal Dre mentioned was consisting of 3 members, 1 Canadian, 1 American, and 1 from Belgium. You actually saw this in the video earlier, including 2 scientists endeavored to make decision on the key questions of the case. The tribunal would use international law practices, American law, and American courts to analyze the facts and evidences. The representatives gave statements, presented evidence and arguments, and investigators appointed on behalf of each government. Now, let's go to the decision of each issue.
On the first issue, whether damage caused by the Trail Smelter in the state of Washington has occurred since the first day of January 1932, it was ruled that yes, the damage caused has occurred since the first day of January 1932 and up to October 1, 1937. The American lawyer's argument can be summarized as trying to prove that invisible injury occurred in the region, however, failed to substantiate it. The United States had conducted experiments that suggested sulfur soaked into the soil. However, the findings had limited standing in the arbitration because the data was from the early 1930s, before the smelter implemented chemical recovery methods. On the other hand, the Canadians had the resources and the smelting industry supporting them. Because of the Canadian lawyer's success in narrowing the definition to the actual observable economic damage, the arbitrators awarded $78,000 in damages for two burns causing visible damage in 1934 and 1936. Interest at the rate of 6 per annum per centum per year will be allowed on the above sum of $78,000 from the date of filing of this report and decision until date of payment. This decision is not subject to alteration or modification by the tribunal hereafter. The fact of existence of damage, if any, occurring after October 1, 1937, and the indemnity to be paid therefore, if any, the tribunal will determine in its final decision. The final statement for damages was awarded in April 1938 and was considered a victory for Comico.
Answering the succeeding question, whether the trail smelter should be required to refrain from causing damage in the state of Washington, in further given that the first issue was positive, and what measures or regime should be adopted or maintained by the trail smelter, the tribunal decided that until final decision should be made, the trail smelter should be subject to temporary regime, described more in detail in part 4 of the present decision, and a trial period was established to a date not later than October 1st, 1940. In order to enable the tribunal to establish a permanent regime based on a more adequate and intensive study, since the tribunal felt that the information that had been placed before it did not enable it to determine at that time with sufficient certainty upon a permanent regime as to the measures, since the tribunal has, in its previous decision, found that damage caused by the trail smelter has occurred in the state of Washington since January 1st, 1932. And since the tribunal is of opinion that damage may occur in the future unless the operation of the smelter shall be subject to some control in order to avoid damage occurring, the tribunal now decides that a regime or measure of control shall be applied to the operation of the smelter and shall remain in full force unless until modified in accordance with the provisions of herein set forth in Section 3, Paragraph 4 of the present part of the decision.
Now, as to the indemnity raised in that last issue, question 4, the tribunal is of opinion that the prescribed regime will probably remove the causes of the present controversy and, as said before, will probably result in preventing any damage of a material nature occurring in the state of Washington in the future, since the desirable and expected result of the regime or measure of control hereby required to be adopted and maintained by the smelter may not occur. If any damage as defined under question 2 shall have occurred since October 1, 1940, or shall occur in the future, whether through failure on the part of the smelter to comply with the regulations herein prescribed, or notwithstanding the maintenance of the regime, an indemnity shall be paid for such damage, but only when and if The two governments shall make arrangements for the disposition of claims for indemnity under the provisions of Article 11 of the Convention.
Moreover, if as a consequence of the decision of the tribunal in its answer to question number 2 and question number 3, the United States shall find it necessary to maintain in the future an agent or agents in the area in order to ascertain whether damage shall have occurred in spite of the regime prescribed herein. The reasonable cost such investigations not in excess of $7,500 in any 1 year shall be paid to the United States as a compensation, but only if and when the two governments determined under Article 11 of the Convention that damage has occurred in the year in question due to the operation of the smelter and disposition of claims for indemnity for damage has been made by the two governments, but in no case shall the aforesaid compensation be payable in excess of the indemnity for damage, and further, it is understood that such payment is hereby directed by the tribunal only as a compensation to be paid on account of the answer of the tribunal to question number 2 and question number 3 as provided for in question number 4, and not as any part of indemnity for the damage to be ascertained and to be determined upon by the two governments under Article 11 of the Convention.
So, this dispute reached to a tribunal award in 1938 and 1941, and the following general principles of international law. Principle 21 of 1972 United Nations Stockholm Declaration that states have, in accordance with Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources pursuant to their own environmental policies, and the responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. Articles 192-194 of the UNCLOS, which states that states have the obligation to protect and preserve the marine environment, and Article 193 states that states have the sovereign right to exploit their national resources pursuant to their environmental policies in accordance with their duty to protect and preserve the marine environment, and states shall take all measures necessary to ensure that activities under their jurisdiction or control are so conducted as not to cause damages by pollution to other states and their environment. And the pollution arising from incidents or activities under their jurisdiction or control does not spread beyond the areas where they exercise sovereign rights in accordance with this convention.
Through these two seminal texts, the trail smelter rule is thus codified into something more precise and, in the latter case, conventional.
So, in summary, it is the responsibility of the state to protect other states against harmful acts by the individuals from within its jurisdiction at all times. No state has the right to use or permit the use of the territory in a manner as to cause injury by fumes in or to the territory of another or properties of persons therein. So, that's it. That's the trail smelters case. So this has been Joanne, Jay, and Pam. Thank you for listening to our presentation. Good day.